For more on what we can expect from this trial, we are joined now by Jacob Frenkel, a partner at Shulman, Rogers, Gandal. He is a former state and federal criminal prosecutor and a former SEC enforcement lawyer. Jacob joins us now live from our Washington newsroom. Thanks so much for joining us. Good to have you here on this Wednesday. And let's start with, a simple question. What makes this such a big deal? We are paying close attention to it, but it's not the first insider trading case.
It's not the first insider trading case, but it's certainly the biggest insider trading case to go to trial probably in 25 years. It's also by far the most significant insider trading case ever to hit the hedge fund industry. And that's evidenced by the fact that 26 people have been charged, 19 have pled guilty, the volume of wiretaps that you've already just referred to, the fact that the government used uncharacteristically aggressive techniques in order to put this case together. And if you talk about the broader Galleon-related insider trading investigation, this is what takes us into the whole discussion we've had of people being charged in the expert networks. So this really goes to the guts of how hedge funds are doing business, information on which hedge funds are trading. That's what makes this case so significant in the financial services industry.
Jacob, let's go back for a second. You mentioned the wiretaps here. That's very unusual for a situation like this. Why is it?
Well, because first of all, it's very difficult for FBI agents or federal law enforcement. And again, I'm going to digress for a second here, because when we're talking about federal law enforcement, we're talking about the FBI. We're talking about criminal law enforcement authorities. The SEC, which is not a law enforcement authority. There's nothing in its legislative history that refers to it as a law enforcement agency. The SEC can't get wiretaps. It's only the FBI that can. But there's a very high threshold for doing so, and they can only get wiretaps after they have exhausted all other investigative steps. And that was something that was the subject of considerable motions practice earlier in the trial. So, not only is it unusual, but there was even questions raised as to whether it was appropriate for the approval of those wiretaps. But what makes them significant is wiretaps are an opportunity for the jury to hear the voice of the accused, to hear the actual words, not be called upon to draw inferences based on efforts to connect the dots, which historically is how the insider trading cases have had to be proved by federal prosecutors. Yes, there will be people in the conversations, part of the conversations, who were involved and will help with the interpretations, but nevertheless, for the jury to be able to hear a defendant's own words, that is very powerful evidence.
Let me ask you, Jacob, having been involved in cases similar to this one, maybe not quite as big in scope, do you think Rajaratnam will be taking the stand, and does that help him? If they're going to hear the voice of the accused in the wiretaps, it would make sense to me that if you were the defendant, that you'd want them to hear your voice in court as well, live.
Lisa, you've hit what ultimately may be the 20-year, $45 million question right on the head. I mean, early on, Raj Rajaratnam publicly took the position that he, in fact, was going to testify. He wanted to be able to speak to the jury. But then you look at some of the high-profile corporate fraud cases. Bernie Ebbers, Jeffrey Skilling testified, and they're sitting in jail. I mean, it's a very difficult decision. And the first cue as to whether that may or may not ultimately occur will come in opening statements today. Because if Mr. Dowd, Mr. Rajaratnam's attorney, actually represents to the jury that he's going to take the stand, you can expect that he will. I would be surprised that he would actually go that far. And that decision will be made based on not only how well the government's evidence is coming in, but how the lawyers and the consultants who are sitting on the defense side perceive how the jury is receiving that evidence and how effective the cross-examination is going to be. So while it's easy to sit back right now and say he should or he shouldn't, and you're absolutely right, the jury always wants to hear from the accused, it's a decision that may not be made until sometime in the defense case.
All right. Well, certainly first day. Looks like it's going to be a long trial by all accounts. Jacob, thanks so much for joining us. We'll have to check in with you as things develop. That was Jacob Frenkel, partner at Shulman, Rogers, Gandal, also a former SEC enforcement lawyer.